All right. So my uncle had a driving without a license case today. He recently had one, and he didn't have the contract. He went and rescinded his contract, rescinded his license, and when they pulled him over, he didn't have one. So they brought him in, and he did the whole thing, not claiming the name, yada yada yada. And they ended up finding him. It went to trial. The jury found him guilty.
Yeah.
But
so he actually did have a jury there?
Yeah, he pushed it to jury.
Okay.
But what ended up happening was after he was done, on his way home, he got picked up again, right?
Yeah.
And after he got home from that, so this is the day of his trial. His trial ends. He goes to a meeting on his way home. He gets pulled over again. They take him in, and then the next day, a couple days later, he gets in the mail something asking him. They wanted to lift the suspension on his license, but there was no license to have a suspension on in the first place, so they were asking him to basically recontract. Right? So of course he just denied it. And then he went in for his court appearance today, and I'm hoping he joins us today. This would be fucking awesome if he joined us today. But he goes in for his court appointment today, and he's in there in traffic court waiting, and they called everybody but him. So then he goes in to see the DA afterwards, after he waited through all of it.
Yeah.
And he asked the DA, and they said, no, we decided not to proceed. And he's like, okay, so Russell Elliott doesn't have any well, he asked if they had any charges for Russell Dumont. They said, no, we decided not to proceed. And he said, so Russell Elliott doesn't have any charges then either? We're good? And he's like, nope, we understand the name. We get it. And so he left.
Wow.
And that was today. That was today.
Okay.
So, yeah, I'm pretty stoked about that because he's also in the midst of a mortgage, and now he's got documentation that they're recognizing him as, you know what I mean? So
now, did they dismiss the case, or was it like they didn't even?
It was gone before it started.
Wow, that's cool.
Same thing happened to me with my first one. Well, this isn't his first one, but my very first one was, I had a 4 or 3.5 horse motor on a Schwinn Chopper Stingray, and I got pulled over for not having a license. And I already knew that I wasn't required to have one anyway, but on top of that, the way that I put my bike together was in a way such that I didn't need to have a license either.
Okay.
So this cop pulls me over, and he held me for like an hour and a half going through his little manual to try and hit me with the statute, something he could find. And this is a constable, by the way, a constable on U.S. soil. I laughed at him right away. I'm like, what are you doing on U.S. soil? You're British. What the hell are you doing here?
What did he say?
He scoffed at me. I'm like, you ain't even got no authority. So anyway, the hour goes by, and he gets called off on another call. He's like, wait right here. I'm like, fuck you. I'm on my lunch break from work. I got to go eat and get back to work. So he left on his call. I went to my house, and I called the sheriff's department. And I said, hey, listen, this is what's going on. I said, your boy left me high and dry in the street and told me to wait there. I said, I ain't waiting. I got money to make. I got to get back to work. I'm going to go eat. I said, I'm calling you guys out of a courtesy to let you know that I'm still moving about doing my business, and I'm going to continue to do so in my lawful capacity. And They said, okay, fine. Thank you. She didn't really know what to say other than that. Hung up. And I finish eating, get back to work. As I'm pulling in over at the mill, son of a bitch pulls in behind me, all up in the dirt. I'm like, motherfucker. I told you. I said, I don't care what you told me. I already called the sheriff's department. And they said I'm good. So he writes me the ticket. And
He
I'm
still
like,
gave you a ticket?
yeah, he writes me a ticket. I'm like, dude, I'm going to wipe my ass with this. You know that, right? And, yeah, that was it for that. And then when I finally went in to deal with it, I went in a couple of hours before it was called for, and I went in and I went to see the DA right off. I didn't do nothing else. I just went to see the DA, and I was like, I don't understand this. Can you explain what this is all about for me? Because I'm an idiot. And I was nervous. Nervous as all hell. That's why I said that. But I had heard somewhere that if you use the word idiot, it gets them to back off of you for some reason.
Well, because then they think of you as a ward, right? If you're saying you're an idiot, then they're like, oh, well, then he's a ward of the court. He's,
But
you know how they consider.
Well, that's what I was thinking. But then she immediately was like, "No, you're good. Just go home."
Huh.
Never even brought me in the courtroom.
Well, that's good. Do you know if he? You said it was your uncle, right?
Yeah.
Do you know if he requested any of the bonds that were attached to the case?
Oh, actually, at his trial, he closed it out by saying, "You better tell the DA not to cash that bond, because if you do, I'm suing."
Oh, shit.
I just found that out a couple hours ago, and I was like, dude, you told me this story 500,000 times, and you never told me that part. What the fuck? I'm like,
yeah,
of course they're gonna dismiss it. You just fucking dropped a ball on their ass.
Yeah, because from what I understand, anytime there's any kind of court case, there's bonds attached to it on the
Every
backside.
time.
And if they dismiss the case, then you're supposed to be asking for them, where's the bond at? Because the plaintiff, or I'm sorry, the attorney bringing the case, they have to bond the case in order to be able to be in there in the first place.
Right.
So
he didn't serve him with a fee schedule.
No, he's having a hard time. It's hard for him to absorb all of it. He's an older gentleman, and he's got some learning issues. Rusty, that's with all respect. When you watch this later, love you. But that's my role, is to kind of help keep all the info intact for him.
Well, I think a lot of it too is like people who are a little bit older. No offense to anybody older than me, because I know I'm kind of old, but
I'm offended.
It's like they're almost stuck in their
How you
ways.
doing, Cal?
Like they see world a certain way, and they think that's how it is. And even like when we try to explain it to them, it's still a little bit hard to grasp, because I mean most of the life it's like this is how it was.
The beautiful thing about my uncle is he's known for a long time. Like, he's known for a long time. A good chunk of the bullshit that's out there as far as what the government's been doing. So this has more all been a confirmation for him, which is really got to be a great, validating feeling.
And he has his UCC filed?
Yes, we both filed our trusts at the same time together, along with his wife. We filed everything through Sovereign Filing Solutions, which basically they just use the Redemption Manual 5.
Okay.
Like, and their documents are on point, dude. It's a great base to start with. Just like Pito said, that's basically, it's right out of the book is pretty much what he did, and they just have it all done up for you, ready to go. $150 was the last time I checked. I still haven't been on that damn site lately. Got to go back. Not that I'm trying to like push them or anything. This is just a deal that I got, and it's a great deal. It's a good, easy way to get secured right off the top, and then you can go back and amend later. You know what I mean? As long as you got your birth certificate authenticated you're golden with the rest, because they've got the whole process down pat. All your Form 56s are ready to go. They do up $100 million silver bond. Done.
Yeah. Hey, do you have a treaty with your UCC filing?
No. What do you mean? I haven't heard anything about a treaty. Enlighten me.
There's another. I'm part of this other group, and the guy that I was talking to, he pretty much was saying, security agreement, power of attorney, hold harmless, copyright, trademark. But he was saying that one of the things that a lot of people are missing is a treaty, because if you're going to be a foreign entity on the soil, you need to have some kind of treaty either with. That's something I don't have yet. I'm not sure if it's with the bank or with the the state or who the treaty is with, or if it's just like one of those peace and friendship treaties to everyone. You know what I'm saying? Like how some of these other people do it.
That's the whole point of registering non-belligerent.
Okay. So non-belligerent is kind of like
non-belligerent is saying I'm at peace, I'm not at war. That's the whole point of that.
Okay.
And this is another thing that I like about sovereign filings is their legal notice and demand, which also acts as your affidavit of life, affidavit of status, all of that, because it's a freaking 8-page document.
Okay.
And it's on point. And the thing that I like about it is right up here, Non-War Powers Act flag. So
what's the difference between that flag and the other flag that has the lines that are vertical and the colors inverted? Have you seen that flag?
Yes, I actually have that flag hanging in my kitchen right now. That is the real civil flag.
Okay. I thought that was the peacetime flag, and then the flag that you just showed was the United States Maritime at War flag.
With the fringe is the Admiralty at war. Without the fringe is still non-war powers.
Okay.
But civil, land is the white.
Okay. Cool.
Well, I'm guessing nobody else is going to show.
Quick, I'm on.
It's all right.
Hold on.
We're going to start things off with an extra special bong hit today. Got some new incense.
Hey, John, when you finish, can we talk about that death certificate PDF that you downloaded yesterday?
Yeah. I haven't had the chance to dig into it much yet.
Just like a 12-page. I haven't either. I downloaded it.
Yeah, I downloaded it. We could probably get into that after the meeting.
Okay.
So as I light this incense, thanks to the gods, thanks to my parents, thanks to my family and friends, thanks to the ancestors, thanks to everybody here that's joining us and helping to bring this knowledge out. Nothing new under the sun. We all know it. It's our time. It's our job. If we don't do it, nobody else will. So with that being said, we take the ceremonial toke from the bong and say thank you. Also, congratulations to my uncle, Russell Elliott, for officially defeating his legal fiction in court today, Russell Dumont. It's a big, big day for him. I don't think he really realizes how big this small victory is, especially the fact that he got them to stand down. So with that being said, what he just did today is a small part of what we're trying to accomplish with the knowledge that we're going over here in these books. We left off last week, subsection 2, part 1 of the short titles. And I believe we were at 2-8 or 2-108, my bad. Has everybody got their copy of this file?
Yes, thank you.
Okay, I just want to make sure that everybody's able to follow along even when we're not.
I don't think I have a copy. Which one is that one?
This is the UCC workbook. If you go in the group files, you should be able to just scroll the page because there aren't that many posts up there yet. Okay. We'll just start from the top of section 2. All right, subsection 2-101, short title. This article shall be known and may be cited as Uniform Commercial Code sales. Subsection 2-102, scope. Certain security and other transactions excluded from this article. Unless the context otherwise requires, this article applies to transactions in goods. It does not apply to any transaction which, although in form of an unconditional contract to sell or present sale, is intended to operate only as a security transaction, nor does this article impair or repeal any statute regulating sales to consumers, farmers, or other specified classes of buyers. Subsection 2-103, definitions and index definitions. In this article, unless the context otherwise requires, a buyer means a person that buys or contracts to buy goods. And then B, conspicuous, with reference to a term, means so written, displayed, or presented that a reasonable person against which it is to operate ought to have noticed it. A term in electronic record intended to evoke a response by an electronic agent is conspicuous if it is presented in a form that would enable reasonably configured electronic agent to take into account or react to it without review of the record by an individual. Whether a term is conspicuous or not is a decision for the court. Conspicuous terms include the following. 1. For a person, A heading in capitals equal to or lesser than the surrounding text, or in contrasting type, font, or color to the surrounding text of the same or lesser size, and B, language in the body of a record or display in larger type than the surrounding text, or in contrasting type, font, or color to the surrounding text of the same size, or set off from the surrounding text of the same size by symbols or other marks that call attention to the language. And 2, for a person or an electronic agent, a term that is so placed in a record or display that the person or electronic agent may not proceed without taking action with respect to the particular term. C, consumer means an individual who buys or contracts to buy goods that, at the time of contracting, are intended by the individual to be used primarily for personal, family, or household purposes. D, consumer contract means a contract between a merchant seller and a consumer. E, delivery means the voluntary transfer of physical possession or control of goods. F, electronic means relating to technology having electrical, digital, magnetic, wireless, optical, electromagnetic, or similar capabilities. G, electronic agent means a computer program or electronic or other automated means used independently to initiate an action or respond to electronic records or performances in whole or in part without review or action by an individual. H, electronic record means a record created, generated, sent, communicated, received, or stored by electronic means. I. Oh, too far. Getting a little click happy. Foreign exchange transaction means a transaction in which one party agrees to deliver a quantity of a specified money or unit of account in consideration of the other party's agreement to deliver another quantity of different money or unit of account either currently or at a future date, and in which delivery is to be through funds transfer, book entry accounting, or other form of payment order, or other agreed means to transfer credit balance. The term includes a transaction of this type involving two or more monies and spot forward option, or other products derived from underlying monies and any combination of these transactions. The term does not include a transaction involving two or more monies in which one or both of the parties is obligated to make physical delivery at the time of contracting or in the future of banknotes, coins, or other form of legal tender or specie. J, reserved. J, good faith means honesty in fact and the observance of reasonable commercial standards of fair dealing. Legislative note: the definition of good faith should not be adopted if the jurisdiction has enacted this definition as a part of Article 1. K, goods, means all things that are movable at the time of identification to a contract for sale. The term includes future goods, specially manufactured goods, the unborn young of animals, growing crops, and other identified things that attach to reality as described in Section 2-107. The term does not include information, the money in which the price is to be paid, investment securities under Article 8, the subject matter of foreign exchange transactions, or chooses an action. L, receipt of goods, means taking physical possession of goods. M, record, means information that is inscribed on a tangible medium or that is stored in electronic or other medium that is retrievable in a perceivable form. Man, my cotton mouth is getting to me. I'm fucking up words left and right. As usual, never going to learn. It's all right. Smoke a lot of weed. Smoke weed every day. Legislative note: the definition of record should not be adopted if the jurisdiction has enacted Article 1. N, remedial promise means a promise by the seller to repair or replace goods or refund all or part of the price of goods upon happening of a specified event. O, seller, means persons that sells or contracts to sell goods. P, signs, means with present intent to authenticate or adopt a record. 1, to execute or adopt a tangible symbol, or 2, to attach or logically associate with the record an electronic sound, symbol, or process. 2, other definitions applying to this article or to specified parts thereof, and the sections in which they appear are acceptance, Section 2-606, between merchants, Section 2-104, cancellation, Section 2-106, subsection 4, commercial unit, Section 2-105, conforming to contract, Section 2-106, contract for sale, Section 2-106, cover, Section 2-712, entrusting, Section 2-403, financing agency, Section 2-104, future goods, Section 2-105, goods, Section 2-103, identification, Section 2-501, installment contract, Section 2-612, lot, Section 2-105, merchant, Section 2-104. Person in position of seller, Section 2-707, present sale, Section 2-106, sale, Section 2-106, sale on approval, Section 2-326, sale or return, Section 2-326, termination, Section 2-106, 3. Control as provided in Section 7-106 and the following definitions in other articles apply to this article. Check Section 3-104 subsection F. Consignee. Section 7-102 subsection 3. Consignor. Section 7-102 subsection 4. Consumer Goods, Section 9-102, subsection A, subsection 23. Dishonor, Section 3-502. That's one we should really study. Draft, Section 3-104E. Honor, Section 5-102, subsection A, subsection 8. Injunction against honor, Section 5-109, subsection B. Letter of credit, Section 5-102, subsection A, subsection 10. 4. In addition, Article 1 contains general definitions and principles of construction and interpretation applicable throughout this article. 2-104. Definitions merchant between merchants, financing agency. 1. Merchant means a person that deals in goods of the kind or otherwise holds itself out by occupation as having knowledge or skill peculiar to the practices or goods involved in the transaction, or to which the knowledge or skill may be attributed by the person's employment of an agent or broker or other intermediary that holds itself out by occupation as having the knowledge or skill. 2, financing agency means a bank, finance company, or other person that is in ordinary course of business, makes advances against goods or documents of title, or by arrangement with either the seller or the buyer, intervenes in ordinary course to make or collect payment due or claimed under the contract for sale, as by purchasing or by paying the seller's draft for making advances against it, or by merely taking it for collection, whether or not documents of title accompany or are associated with the draft. The term includes also a bank or other person that similarly intervenes between persons that are in position of seller and buyer in respect to the goods. Section 2-707. 3. Between merchants means in any transaction with respect to both parties are chargeable with the knowledge or skill of merchants. Subsection 2-105, definitions, transferability, future goods, lot, commercial unit. 1. Goods must be both existing and identified before any interest in them may pass. Goods that are not both existing and identified are future goods. A purported present sale of future goods or of any interest therein operates as a contract to sell. 2. There may be a sale of a part interest in existing identified goods. 3. An undivided share in an identified bulk of fungible goods is sufficiently identified to be sold, although the quantity of the bulk is not determined. Any agreed proportion of the bulk or any quantity thereof agreed upon by number, weight, or any other measure may, to the extent of the seller's interest in the bulk, be sold to the buyer that then becomes an owner in common. 4. Lot means a parcel or a single article which is the subject matter of a separate sale or delivery, whether or not it is sufficient to perform the contract. You guys got me all right?
Yes, thank you.
Okay, all right. Just making sure. We've had plenty of issues up until now. So, 5. Commercial unit means such a unit of goods as by commercial usage in a single whole for purposes of sale. Sorry, let me reread that. Commercial unit means such a unit of goods as by commercial usage is a single whole for purposes of sale and division of which materially impairs its character or value upon the market or in use. Okay, got that now. A commercial unit may be a single article, as a machine, or a set off of articles, as a suite or furniture or an assortment of sizes, or a quantity as a bale, gross, or carload, or any other unit treated in use or in the relevant market as a single whole. Subsection 2-106, definitions of contract, agreement, contract sale, sale, present sale, conforming to contract, termination, cancellation. In this article, unless the context otherwise requires, contract and agreement are limited to those relating to the present or future sale of goods. Contract for sale includes both present sale of goods and a contract to sell goods at a future time. A sale consists in the passing of title from the seller to the buyer for a price, Section 2-401. A present sale means a sale which is accompanied by the making of a contract. 2. Goods or conduct, including any part of a performance, are conforming or conform to the contract when they are in accordance with the obligations under the contract. 3. Termination occurs when either party, pursuant to a power created by agreement or law, puts an end to the contract, otherwise than for its breach. On termination, all obligations which are still executory on both sides are discharged, but any right based on prior breach or performance survives. 4. Cancellation occurs when either party put an end to the contract for breach by the other, and its effect is the same as that of termination, except that the canceling party also retains any remedy for breach of the whole contract or any unperformed balance. Subsection 2-107, goods to be severed from realty, recording. Might as well be severed from reality. 1. A contract for the sale of minerals or the like, including oil and gas, or structures or its materials, to be removed from realty is a contract for the sale of goods within this article if they are to be severed by the seller, but until severance, a purported present sale thereof, which is not effective as a transfer of an interest in land, is effective only as a contract to sell. I'm going to read that again. That is one long sentence. A contract for the sale of minerals or the like, including oil and gas, or a structure or its materials to be removed from realty is a contract for the sale of goods within this article if they are to be severed by the seller, but until severance, a purported present sale thereof, which is not effective as a transfer of an interest in land, is effective only as a contract to sell. All right. 2. A contract for the sale, apart from the land, of growing crops or other things attached to realty and capable of severance without material harm thereto, but not described in subsection 1, or of timber to be cut, is a contract for the sale of goods within this article, whether the subject matter is to be severed by the buyer or by the seller, even though it forms part of the realty at the time of contracting, and the parties can, by identification, effect a present sale before severance. 3. Provisions of this section are subject to any third-party rights provided that the law relating to realty records and the contract for sale may be executed and recorded as a document transferring an interest in land and shall then constitute notice to third parties of buyer's rights under the contract for sale. Subsection 2-108, transactions subject to other law. 1. A transaction subject to this article is also subject to any applicable A. List any certificate of title, statutes of... Hang on. Transaction subject to this article is also subject to any applicable... Okay. List any certificates of title, statutes of this state covering automobiles, trailers, mobile homes, boats, farms, tractors, or the like, except with respect to the rights of a buyer in ordinary course of business under Section 2-403, subsection 2, which arise before a certificate of title covering the goods is effective in the name of any other buyer. B. rule of law that establishes a different rule for consumers, or C, statute of this state applicable to the transaction, such as a statute dealing with excuse me. 1, the sale or lease of agricultural products. 2, the transfer of human blood, blood products, tissues, or parts. 3, the consignment or transfer by artists of work or arts of fine prints. You can tell this shit was written by vampires right here. 4, distribution agreements, franchises, and other relationships through which goods are sold. 5, the misbranding or adulteration of food products or drugs. And 6, dealers in particular products such as automobiles, motorized wheelchairs, agricultural equipment, and hearing aids. 2, except for the rights of a buyer in ordinary course of business under subsection 1A, in the event of a conflict between this article and the law referred to in subsection 1, that law governs. 2, except for the rights of a buyer in ordinary course of business under subsection 1A, in the event of conflict between this article and law referred to in subsection 1, that law governs. Okay, sorry. Numbers and letters throw me off. 3, for purposes of this article, failure to comply with the law referred to in subsection 1 has only the effect specified in that law. 4, the article modifies, limits, and supersedes the Federal Electronic Signatures in Global and National Commerce Act 15 U.S.C. Section 7001, except that nothing in this article modifies, limits, or supersedes Section 70001, subsection C of that act, or authorizes electronic delivery of any of the notices described in Section 7003, subsection B of that act. Part 2, form, formation, and readjustment of contract. Subsection 2-201, formal requirements, statutes of frauds. 1, a contract for the sale of goods for the price of $5,000 or more is not enforceable by way of action or defense unless there is some record sufficient to indicate that a contract for sale has been made between the parties and signed by the party against which enforcement is sought, or by the party's authorized agent or broker. A record is not sufficient because it omits or incorrectly states a term agreed upon, but the contract is not enforceable under this subsection beyond the quantity of goods shown in the record. 2, between merchants, if within a reasonable time a record in confirmation of the contract and sufficient against the sender is received, and the party receiving it has reasons to know its contents, it satisfies the requirements of subsection 1 against the receipt unless notice of objection is to its contents given in a record within 10 days after it's received. 3, a contract that does not satisfy requirements of subsection 1 but which is valid in other respects is enforceable. I'll start that again. 3, a contract that does not satisfy the requirements of subsection 1 but which is valid in other respects is enforceable. A, if the goods are to be specially manufactured for the buyer and are not suitable for sale to others in ordinary course of the seller's business, and the seller before notice of repudiation is received and under circumstances that reasonably indicate that the goods are for the buyer, has made either a substantial beginning of their manufacture or commitments for their procurement. B, if the party against which enforcement is sought admits in the party's pleading or in the party's testimony or otherwise under oath that the contract for sale was made, but the contract was not enforceable under this paragraph beyond the quantity of goods admitted, or C, with respect to goods for which payment has been made and accepted, or which have been received and accepted. Section 2-606. 4. A contract that is enforceable under this section is not unenforceable merely because it is not capable of being performed within 1 year or any other period of time after its making. Subsection 2-202. Final expression in a record, parole, or extrinsic evidence. That X got me. 1. Terms with respect to which the confirmatory records of the parties agree, or which are otherwise set forth in a record intended by the parties as final expression of their agreement with respect to such terms that are included therein may not be contradicted by evidence of any prior agreement or of a contemporaneous oral agreement, but may be supplemented by evidence of a course of performance, course of dealing, or usage of trade, section 1-303. Contemporaneous. I'm going to have to look that word up. I'm guessing it probably just means old. Contemporary. B. Consistent additional terms unless the court finds the record to have been intended also as a complete and exclusive statement of the terms in the agreement. 2. Terms in a record may be explained by evidence of course of performance, course of dealing, or usage of trade without preliminary determination by the court that the language used is ambiguous. Subsection 2-203. Seals inoperative. The affixing of a seal to a record evidencing a contract for sale or an offer to buy or sell goods does not constitute the record of a sealed instrument. The law with respect to sealed instruments does not apply to such a contract or offer. 2-204. Formation in general. 1. A contract for sale of goods may be made in any manner sufficient to show agreement, including offer and acceptance, conduct by both parties, which recognizes the existence of a contract. In the interaction of electronic agents and the interaction of an electronic agent and an individual. 2. An agreement sufficient to constitute a contract for sale may be found even if the moment of its making is undetermined. 3. Even if one or more terms are left open, a contract for sale does not fail for indefiniteness if the parties have intended to make a contract and there is a reasonably certain basis for giving an appropriate remedy. Sorry, I'll do that again. 3. Even if one or more terms are left open, a contract for sale does not fail for indefiniteness if the parties have intended to make a contract and there is a reasonably certain basis for giving an appropriate remedy. 4. Except as otherwise provided in sections 2-211 through 2-213, the following rules apply. A contract may be formed by the interaction of electronic agents of the parties, even if no individual was aware or reviewed the electronic agents' actions or the resulting terms and agreements. B. A contract may be formed by the interaction of an electronic agent and an individual acting on the individual's own behalf or for another person. A contract is formed if the individual takes actions that the individual is free to refuse to take or makes a statement, and the individual has reason to know that the actions or statements will 1. Cause the electronic agent to complete the transaction or performance, or 2. Indicate acceptance of an offer regardless of other expressions or actions by individual to which the electronic agent cannot react. 2-105. Firm offers. An offer by a merchant to buy or sell goods in a signed record that by its terms gives an assurance that it will be held open is not revocable for lack of consideration during the time stated, or if no time is stated, for a reasonable time, but in no event may such period of irrevocability exceed 3 months, but in no event may the period of irrevocability. Why did they must typoed that. 1, 2. Damn. Any such term of assurance in a form supplied by the offeree must be separately signed by the offeror. But in no event. Huh. That's. Sorry. I don't know why that's dumbfounded me for some reason. Subsection 2-206. Offer and acceptance in formation of contract. Nom. 1. Unless otherwise unambiguously indicated by the language or circumstances, A, an offer to make a contract shall be construed as inviting acceptance in any manner and by any medium reasonable to the circumstances, in the circumstances. B, an order or other offer to buy goods for prompt or current shipment shall be construed as inviting acceptance either by a prompt promise to ship or by the prompt or current shipment of conforming or non-conforming goods, but the shipment of non-conforming goods is not an acceptance if the seller seasonably notifies the buyer that the shipment is offered only as an accommodation to the buyer. 2. If the beginning of a requested performance is a reasonable mode of acceptance, an offerer that is not notified of acceptance within a reasonable time may treat the offer as having lapsed before acceptance. 3. A definite and seasonable expression of acceptance in record operates as an acceptance even if it contains terms additional to or different from the offer. So that's like that one dude that wrote in a different contract on the bottom of his credit card contract stating that he wouldn't have any payment and he wasn't liable for any charges and it was 0% interest and all that. And then when he defaulted on purpose, after buying a whole ton of, they came after him and he produced a copy of the contract. They produced the same contract and they're like, oh, we didn't read the fine print. And they held up the fact that, he has the right to unlimited contract. So that was pretty cool. Anyway, back to it. Subsection 2-207. Terms of contract, effective confirmation. Subject to section. Wow, I really fucked that one up. Subject to section 2-202. If 1, conduct by both parties recognizes the existence of a contract, although their records do not otherwise establish a contract. 2, a contract is formed by an offer and acceptance. Or 3, a contract formed in any manner is confirmed by a record that contains terms additional to or different from those in the contract being confirmed. The terms of the contract are A, terms that appear in the records of both parties. B, terms whether in a record or not, which show both parties agree. And C, terms supplied or incorporated under any provision of this act. 2-208, reserved. We'll have to look that one up. I can't believe that there's nothing there. Somebody want to Google that for me? Actually, you know what? I'm going to look it up right now. Not my Google. Oh, that's right. You know what? You know who I forgot to thank at the top of the meeting? The lovely Kennebec County District Attorney, Megan Maloney. Thank you so much. Sorry, my Google page had her up still, so. CC. Anybody know how to do this little subsection symbol?
What symbol, man?
Oh, never mind. All right. We will fix this little hole here.
I put it in chat.
What, 2-208?
Yes.
Oh, you are just awesome. Hey, when I got my trust completely filled out and done and ready to go, I'll hire you as my secretary, okay?
I'm already booked.
Where the heck is the chat? Oh yeah, it's over here. Sorry, I've got my share screen has all the controls, and that's on the different screen of everything else. Bam! There it is. I'll bring that right over here. Cut off my screen.
Course of performance or practical constructions, where the contract for sale involves repeat occasions for performance by either party with knowledge of the nature of the performance, opportunity for objection.
Oh, hey. Okay, so Marie, you want to get Foxit PDF. That's the program that you want. If you
Foxit.
Yep.
Okay.
If somebody wants to read for a second, I have to go use the restroom.
Are we at 209?
Go do 208, the one that you just posted.
Oh, okay.
Read so that we can get it on video. Thank you.
2-208 of UCC. Course of performance or practical construction. 1. Where the contract for sale involves repeated. Let me check to make sure I'm not muted. Okay.
I hear you.
Okay. Where the contract for sale involves repeated occasions for performance by either party with knowledge of the nature of the performance and opportunity for objection to it by the other, any course of performance accepted or acquiesced in without objection shall be relevant to determine the meaning of the agreement. 2. The express terms of the agreement and any such course of performance, as well as any course of dealing and usage of trade, shall be construed whenever reasonable as consistent with each other. But when such construction is unreasonable, express terms shall control course of performance, and course of performance shall control both course of dealing and usage of trade. Section 1-205. 3. Subject to the provisions of the next section on modification and waiver, such course of performance shall be relevant to show a waiver or modification of any term inconsistent with such course of performance. Well, that's something we need to memorize. That 2-208, then 2. I'll read 2-209. Modification, rescission, and waiver. 1. An agreement modifying a contract within this article needs no consideration to be binding. 2. An agreement in a signed record, which excludes modification or rescission except by a signed record, may not be otherwise modified or rescinded, but except as between merchants, such as requirement in a form supplied by the merchant must be separately signed by the other party. 3. The requirements of Section 2-201 must be satisfied if the contract as modified is within its provisions. 4. Although an attempt at modification or rescission does not satisfy the requirements of subsection 2 or 3, it may operate as a waiver. We just okay, we just completed what's on the screen.
Where are we at?
We're at 5 right there.
All right. Excuse me, guys. Sorry about that.
It's okay.
Trying to deal with that kidney stone. I took I got these little gummies that are 500 milligrams of cranberry extract each, right? You're only supposed to take one a day. I've got 5 left, and I bought the bag yesterday, and there's 30. So, yeah. It's been a fun day. Lots of water, and I think I might have actually passed it. So, woo. All right, 5.
Where are you reading from, man?
Right here on the screen. Do you see where I'm at?
How do you pull that up? Because all I have is just pictures of everyone. I don't have what you're reading.
Is anybody else not seeing it?
Do you pull it up in shared content?
I'm sharing it. You should be able to pull it up there.
Okay.
I'll wait till you're ready.
Go ahead and read, John, because you're recording. I'll search it.
All right. Where were we? 5. A party that has made a waiver affecting an executory portion of a contract may retract the waiver by reasonable notification received by the other party that strict performance will be required if of any term waived, unless the retraction would be unjust in view of the material change of position in reliance on the waiver. Subsection 2-210. Delegation of performance, assignments of rights. 1. If the seller or buyer assigns rights under a contract, the following rules apply. A. Subject to paragraph B and except as otherwise provided in section 9-406 or as otherwise agreed, all rights of the seller or buyer may be assigned unless the assignment would materially change the duty of the other party, increase materially the burden or risk imposed upon the party by the contract, or impair materially that party's chance of obtaining return performance. A right to damages for breach of the whole contract or a right arising out of the assigner's due performance of its entire obligation may be assigned despite an agreement otherwise. B. The creation, attachment, perfection, or enforcement of a security interest in the seller's interest under a contract is not an assignment that materially changes the duty or materially increases the burden or risk imposed on the buyer or materially impairs the buyer's chance of obtaining return performance under paragraph A, unless and only to the extent that enforcement of the security's interest results in a delegation of material performance of the seller. Even in that event, the creation, attachment, perfection, and enforcement of the security interests remain effective. However, the seller is liable to the buyer for damages caused by the delegation to the extent that the damages could not reasonably be prevented by the buyer, and a court may grant other appropriate relief, including cancellation of the contract or an injunction against enforcement of the security's interests or consummation of the enforcement. 2. If the seller or buyer delegates performance of its duties under a contract, the following rules apply. A. A party may perform its duties through a delegate unless otherwise agreed or unless the other party has substantial interest in having the original promisor perform or control the acts required by the contract. Delegation of performance does not relieve the delegating party of any duty to perform or liability of breach. B. Acceptance of a delegation of duties by the assignee constitutes a promise to perform those duties. The promise is enforceable by either the assignor or the other party to the original contract. C. The other party may treat the delegation of duties as creating reasonable grounds for insecurity and may, without prejudice to its rights against the assigner, demand assurances from the assignee under Section 2-609. D. A contractual term prohibiting the delegation of duties otherwise delegable under paragraph A is enforceable and attempted delegation is not affected. And an attempted delegation is not effective. 3. Assignment of the contract or of all of my rights under the contract or an assignment in similar general terms is an assignment of rights, and unless the language or the circumstances as in an assignment for security indicate the contrary, it is also a delegation of performance of the duties of the assigner. 4. Unless the circumstances indicate the contrary, a prohibition of assignment of the contract is to be construed as barring only the delegation to the assignee of the assigner's performance. 2-211. Legal recognition of electronic contracts, records, and signatures. 1. A record or signature may not be denied legal effect or enforceability solely because it is in electronic form. 2. A contract may not be denied legal effect or enforceability solely because an electronic record was used in its formation. 3. This article does not require a record or signature to be created, generated, sent, communicated, received, stored, or otherwise processed by electronic means or in electronic form. 4. A contract formed A contract formed by the interaction of an individual and an electronic agent under Section 2-204, subsection 4 and subsection B does not include terms provided by the individual if the individual had reason to know that the agent could not react to the terms as provided. 2-212. Attribution. An electronic record or electronic signature is attributable to a person if it was the act of the person or the person's electronic agent or the person is otherwise legally bound by the act. Subsection 2-213. Electronic communication. 1. If the receipt of electronic communication has a legal effect, it has that effect if no individual is aware of its receipt. 2. The receipt of electronic acknowledgement of an electronic communication. Receipt of an electronic acknowledgement of an electronic communication establishes that the communication was received, but in itself does not establish that the content sent corresponds to the content received. Part 3. General obligation and construction of contract. 2-301. General obligations of parties. The obligations of the seller is to transfer and deliver, and that of the buyer is to accept. The obligation of the seller is to transfer and deliver, and that of the buyer is to accept and pay in accordance with the contract. Subsection 2-302. Unconscionable contract or term. 1. If the court, as a matter of law, finds the contract or any term of the contract to have been unconscionable at the time it was made, the court may refuse to enforce the contract, or it may enforce the remainder of the contract without the unconscionable term, or it may so limit the application of any unconscionable term as to avoid any unconscionable result. 2. If it is claimed or appears to the court that the contract or any term thereof may be unconscionable, the party shall be afforded a reasonable opportunity to present evidence as to its commercial setting, purpose, and effect to aid the court in making determination. Subsection 2-303, allocation or division of risks. Where this article allocates a risk or a burden as between the parties unless otherwise agreed, the agreement may not only shift the allocation but may also divide the risk or burden. 2-304, price payable in money, goods, realty, or otherwise. 1. The price may be made payable in money or otherwise. If it is payable in whole or in part in goods, each party is a seller of the goods that the party is to transfer. 2. Even if all or part of the price is payable in an interest in real property, the transfer of the goods and the seller's obligations with reference to them are subject to this article, but not the transfer of the interest in real property or the transfer's obligation in connection therewith. 2-305, open price term. 1. The parties, if they so intend, may conclude a contract for sale even if the price is not settled. In such a case, the price is reasonable. In such a case, the price is a reasonable price at the time for delivery if A, nothing is said as to price, B, the price is left to be agreed by the parties and they fail to agree, or C, the price is to be fixed in terms of some agreed market or other standard as set or recorded by a third person or agency and is not set or recorded. 2. A price to be fixed by the seller or by the buyer means a price to be fixed in good faith. 3. If a price left to be fixed otherwise than by agreement of the parties fails to be fixed through fault of one party, the other may, at the party's option, treat the contract as canceled, or the party may fix a reasonable price. 4. If, however, the parties intend not to be bound unless the price is fixed or agreed, and it is not fixed or agreed, there is no contract. In such a case, the buyer must return any goods already received, or if unable to do so, must pay their reasonable value at the time of delivery, and the seller must return any portion to the price, any portion of the price paid on account. All right. 2-306, output requirements and exclusive dealings. 1. A term which measures the quantity by the output of the seller or the requirements of the buyer means such actual output or requirements as may occur in good faith, except that no quantity unreasonably disproportionate to any stated estimate or in the absence of a stated estimate to any normal or otherwise comparable prior to output or requirements may be tendered or demanded. 2. A lawful agreement by either the seller or the buyer for exclusive dealing in the kind of goods concerned imposes unless otherwise agreed on a lawful agreement by either the seller or the buyer for exclusive dealing in the kind of goods concerned imposes unless otherwise agreed on. I smell something burning. Hang on. There's something throwing me off.
John, you cooking water again?
Don't burn your incense in a seed pod, folks. I'm like, what the fuck is that smell? Just can't fucking stop thinking about it. All right, where was I? A lawful agreement by either the seller or the buyer for exclusive dealing in the kind of goods concerned imposes, unless otherwise agreed, an obligation by the seller to use best efforts to supply the goods and by the buyer to use the best efforts to promote their sale. I gotta open a window. This shit stinks. All right, my bad, y'all. Two 307 delivery in single lot or several lots. Unless otherwise agreed, all goods called for by a contract for sale must be tendered in a single delivery, and payment is due only on such tender, but where the circumstances give either party the right to make or demand delivery in lots, the price, if it can be apportioned, may be demanded for each lot. Sorry, I'm too tired. Unless otherwise agreed, all goods called for by a contract for sale must be tendered in a single delivery, and payment is due only on such tender, but where the circumstances give either party the right to make or demand delivery in lots, the price, if it can be apportioned, may be demanded for each lot. Got it. So if you can split it up, split it up. Subsection 2-308. Absence of specified place for delivery. Unless otherwise agreed, A, the place for delivery of goods is the seller's place of business, or if none, the seller's residence. But B, in a contract for sale of identified goods which to the knowledge of the parties at the time of the contracting are in some other place, that place is the place for their delivery. And C, documents of title may be delivered through customary banking channels. So courts. Subsection 2-309. Absence of specific time provisions. Notice of termination. 1. The time for shipment or delivery or any other action under a contract, if not provided in this article or agreed upon, shall be reasonable time. 2. If the contract provides for successful performance but is indefinite in duration, it is valid for a reasonable time, but unless otherwise agreed, may be terminated any time by either party. 3. Termination of a contract by one party, except on the happening of an agreed event, requires that reasonable notification be received by the other party, and an agreement dispensing with notifications is invalid if the operation would be unconscionable. A term specifying standards for the nature and timing of the notice is enforceable if the standards are not manifestly unreasonable. 2-310. Open time for payment on running of credit, authority to ship under reservation. Unless otherwise agreed, A, payment is due at the time and place which the buyer is to receive the goods, even though the place of the shipment is the place of delivery. B, if the seller is required to or authorized to send the goods, the seller may ship them under reservation and may tender the documents of title, but the buyer may inspect the goods after their arrival before payment is due, unless the inspection is inconsistent with the terms of the contract. Section 2-513. C, if tender of delivery is agreed to be made by way of documents of title otherwise than by paragraph B, then payment is due regardless of whether the goods are to be received. 1, at the time and place which the buyer is to receive the delivery of the tangible document, or 2, at the time the buyer is to receive delivery of the electronic documents in the seller's place of business, or if none, the seller's residence. And D, if the seller is required or authorized to ship the goods on the credit period runs from the time of shipment, but post-dating the invoice or delaying its dispatch will correspondingly delay the starting of the credit period. 2-311. Options and cooperation respecting performance. 1. An agreement for sale which is otherwise sufficiently definite, section 2-204, subsection 3, to be a contract is not made invalid by the fact that it leaves particulars of performance to be specified by one of the parties. Any such specification may be made in good faith and within limits set by commercial reasonableness. 2. Unless otherwise agreed, specifications relating to assortment of the goods are at the buyer's option, and specifications or arrangements relating to shipment are at the seller's options. 3. If the specification would materially affect the other party's performance but not seasonably made, or if one party's cooperation is necessary, to the agreed performance of the other but is not seasonably forthcoming, the other party, in addition to all other remedies, A, is excused for any resulting delay in that party's performance, and B, may also either proceed to perform in any reasonable manner or after the time of material or after the time for a material part of that party's performance, treat the failure to specify or cooperate as breach by failure to deliver or accept the goods. Butchered the hell out of that. B, may also either proceed to perform in any reasonable manner or after the time for a material part of that party's performance, treat the failure to specify or to cooperate as breach by failure to deliver or accept the goods. Yay! Subsection 2-312. Warranty of the title against infringement. Buyer's obligations against infringement. 1. Subject to subsection 3. There is in a contract for sale a warranty by the seller that A, the title conveyed shall be good and is transferred rightful and shall not unreasonably expose the buyer to litigation because of any colorable claim to or interest in the goods, and B, the goods shall be delivered free from any security interest or other lien or encumbrance of which the buyer at the time of contracting has no knowledge. Wonder how that plays out for car notes and mortgages. 2, unless otherwise agreed, a seller that is a merchant regularly dealing in goods of the kind warrants that the goods shall be delivered free from rightful claim of any third person by way of infringement or the like, but a buyer that furnishes specifications to the seller must hold the seller harmless against any such claim that arises out of compliance with said specifications. 3, a warranty under this section may be disclaimed or modified only by specific language or by circumstances that give the buyer reason to know that the seller does not claim the title, that the seller is purporting to sell only the right or the title as the seller or a third person may have. That the seller is purporting to sell only the right or title as the seller or a third person may have. What? Or that the seller is selling subject to any claims of infringement or the like. That one confused me, guys. I'm sorry. Subsection 2-313, express warranties by affirmation. Promise. You know what? I should just read that again. 3, a warranty under this section may be disclaimed or modified only by specific language or by circumstances that give the buyer reason to know that the seller does not claim title. The seller is purporting to sell only the right or title as the seller or a third person may have. Or that the seller is selling subject to any claims of infringement or the like. I don't know. I'll have to study that one. Subsection 2-313. Express warranties by affirmation, promise, description, sample. 1. In this section, immediate buyer means a buyer that enters into a contract with the seller. 2. Express warranties by the seller to the immediate buyer are created as follows. Express warranties by the seller to the immediate buyer are created as follows. Express warranties by the seller to the immediate buyer are created as follows. A. Any affirmation of fact or promise made by the seller which relates to the goods and becomes part of the basis of the bargain creates an express warranty that the goods shall conform to the affirmation or promise. B. Any description of the goods which is made part of the basis or bargain creates an express warranty that the goods shall conform to the description. C. Any sample or model that is made part of the basis of the bargain creates an express warranty that the whole of the goods shall conform to the sample or model. So basically all that says is, are you getting what it's describing? 3. It is not necessary to the creation of an express warranty that the seller use formal words such as warrant or guarantee, or that the seller has specific intention to make a warranty, but an affirmation merely of the value of the goods or a statement purporting to be merely the seller's opinion or commendation of the goods does not create a warranty. 4. Any remedial promise made by the seller to the immediate buyer creates an obligation that the promise will be performed upon the happening of the specified event. So know when to keep your mouth shut. Subsection 2-313A, obligation to remote purchaser created by record packaged with or accompanying goods. 1. In this section, A, immediate buyer means a buyer that enters into a contract with the seller. B, remote purchaser means a person that buys or leases goods from an immediate buyer or the person in the normal chain of distribution or other person in the normal chain of distribution. 2, this section applies only to new goods and goods sold or leased as new goods in a transaction of purchase in the normal chain of distribution. 3, if in a record packaged with or accompanying the goods, the seller makes an affirmation of fact or promise that relates to the goods, provides a description that relates to the goods, or makes remedial promise, and the seller reasonably expects the record to be, and the record is, furnished to the remote purchaser, the seller has an obligation to the remote purchaser that A, the goods will conform to the affirmation of fact, promise, or description, unless a reasonable person in the position of the remote purchaser would not believe that the affirmation of fact, promise, or description created an obligation, and B, the seller will perform the remedial promise. 4, it is not necessary for the creation of an obligation under this section that the seller use formal words such as warrant or guarantee, or that the seller has specific intention to undertake an obligation, but an affirmation merely of the value of goods or a statement purporting Why did they list that a second time? I feel like I repeated that. Okay, all right. Sorry. Felt like I was repeating myself for a second. It is not necessary to the creation of an obligation under this section that the seller use formal words such as warrant or guarantee, or that the seller have a specific intention to undertake an obligation, but an affirmation merely of the value of goods or a statement purporting to be merely the seller's opinion or commendation of the goods does not create an obligation. 5. The following rules apply to remedies for breach of obligation created under this section. A, the seller may modify or limit the remedies available to the remote purchaser if the modification or limitation is furnished to the remote purchaser no later than the time of purchase, or the modification or limitation is contained in the record that contains an affirmation of fact, promise, or description. B, subject to modification or limitation of remedy, a seller in breach is liable for incidental or consequential damages under Section 2-715, but not for lost profits. C, the remote purchaser may recover as damages for breach of a seller's obligation arising under subsection 3, the loss resulting in ordinary course of events as determined in any reasonable manner. I got shit popping up on my screen over here, bugging me. 6, an obligation that is not remedial promises is breached if the goods did not conform to the affirmation of fact, promise, or description, creating an obligation when the goods left the seller's control. 2-313B, obligation to the remote purchaser created by communication to the public. 1, in this section, A, immediate buyer means the buyer that enters into a contract with the seller. B, remote purchaser means a person that buys or leases goods from an immediate buyer or other person in the normal chain of distribution. 2, this section applies only to new goods and goods sold and leased as new goods in a transaction of purchase in the normal chain of distribution. I feel like that's the whole same page. It is. Yeah. So it's just repeating itself right here. Remote purchaser, maybe. Yeah, that's pretty much. All right, so basically everything this setup here for a regular purchase is repeated down here for remote purchase. Blah, blah. All right. Subsection 2-314, implied warranty, merchantability, usage of trade. 1. Unless excluded or modified, section 2-316, a warranty that the goods shall be merchantable is implied in a contract for their sale if the seller is a merchant with respect to the goods of that kind. Under this section, the serving for value of food or drink to be consumed either on the premises or elsewhere in the sale. 2. Goods to be merchantable must be at least such as A. Pass without objection in the trade under contract description. B. In case of fungible goods, Mika, quiet. In case of fungible goods, are of fair average quality with the description. C. Are fit for ordinary purpose for which goods of that description are used. D. Run within the variations permitted by the agreement of even kind, quality, and quantity within each unit and among all units involved. Mika, hush. Go lay down. Go to your bed. Go on. You ain't about to be nobody. Shoot. Daddy's trying to read. E. Are adequately contained, packaged, and labeled as the agreement may require. And F. Conform to the promise or affirmations of fact made on the container or label, if any. 3. Unless excluded or modified, section 2-316, other implied warranties may arise from course of dealing or usage of trade. 2-315, implied warranty, fitness for a particular purpose. Where the seller at the time of contracting has reason to know any particular purpose for which the goods are required, and that the buyer is relying on the seller's skill or judgment to select or furnish suitable goods, there is, unless excluded or modified under the next section, an implied warranty that the goods shall be fit for such purpose. 2-316. Exclusion or modification of warranties. 1. Words or conduct relevant to the creation of an express warranty, and words or conduct tending to negate or limit warranty shall be construed, wherever reasonable, as consistent with each other. But subject to section 2-202, negation or limitation is inoperative to the extent that such construction is unreasonable. All right, so we will stop right there for a few minutes. It's 8:30. We'll take a little bit of a break. Kind of get off the continual straight up reading. Anybody have any questions, any thoughts?
Yeah, when he talked about units, ran across my mind units of certificates.
Okay.
You talk sales of units. What do you think?
It would either have to be that or units of silver.
Can we go to that part?
Where was it again? Where were we at? I was just reading, so y'all have to. Like I was just.
Right. Because you can give and sell units of certificates away.
Yeah, that's yeah. Well, that's the whole point. That's trading in securities.
That just stood out to me.
I think I can't remember where it was, and I'm gonna mess around and get lost.
You should look up the word shire, S-H-I-R-E, in the fifth law, Black's Fifth.
Oh yeah.
Yeah, and read about the division of counties, the word count, coin, heads. All these things have to do with how they get calculate the money that they get from us. And also units pertain, with the UCC, they want to put a unit value for every single thing, like every type of document will have a certain type of units assigned to it, I believe.
Right. They want to put a number value to everything.
Mm-hmm.
Because of it being commercial.
Mm-hmm.
Yeah. Where were we at when I stopped? Oh, I think we were right around here, weren't we? Fitness, particular purpose. I think we were right about here. Uh-oh, I feel like did I lose anybody?
Nope.
All right. Hey, Marie.
Yeah.
You want to read for a little bit?
Okay. 2-316, exclusion or modification of warranties. Words or conduct relevant to the creation of an express warranty and words or conduct tending to negate or limit warranty shall be construed wherever reasonable as consistent with each other, but subject to Section 2-202, negation or limitation is inoperative to the extent that such construction is unreasonable. 2. Subject to subsection 3, to exclude or modify the implied warranty of merchantability or any part of it in a consumer contract, the language must be in a record, be conspicuous, and state, the seller undertakes no responsibility for the quality of the goods except as otherwise provided in this contract. And in any other contract, the language must mention merchantability and, in case of a record, must be conspicuous. Subject to subsection 3, to exclude or modify the implied warranty of fitness, the exclusion must be in a record and be conspicuous. Language to exclude all implied warranties of fitness in a consumer contract must state, the seller assumes no responsibility that the goods will be fit for any particular purpose for which you may be buying these goods, except as otherwise provided in the contract. And in any other contract, the language is sufficient if it states, for example, that there are no warranties that extend beyond the description on the face hereof. Language that satisfies the requirements of this subsection for the exclusion or modification of a warranty in a consumer contract also satisfies the requirements for any other contract. 3. Notwithstanding subsection 2. A. Unless the circumstances indicate otherwise, all implied warranties are excluded by expressions like as is, with all faults, or other language that in common understanding calls the buyer's attention to the exclusion of warranties, makes plain that there is no implied warranty, and in a consumer contract evidenced by record is set forth conspicuously in the record. B. If the buyer before entering into the contract has examined the goods or the sample or model as fully as desired, or has refused to examine the goods after a demand by the seller, there is no implied warranty with regard to defects that an examination in the circumstances should have revealed to the buyer. And C. An implied warranty may also be excluded or modified by course of dealing or course of performance or usage of trade. 4. Remedies for breach of warranty may be limited in accordance with sections 2-718 and 2-719. Section 2-317, Accumulation and Conflict of Warranties, express or implied. Warranties, whether express or implied, shall be construed as consistent with each other and as cumulative, but if such construction is unreasonable, the intention of the parties shall determine which warranty is dominant. In ascertaining that intention, the following rules apply. A. Exact or technical specifications displace an inconsistent sample or model or general language of description. B. A sample from an existing book displaces inconsistent general language of description. C. Express warranties displace inconsistent implied warranties other than an implied warranty of fitness for a particular purpose. Section 2-318, Third-party beneficiaries of warranties, express or implied. 1. In this section, A. Immediate buyer means a buyer that enters into a contract with the seller. B. Remote purchaser means a person that buys or leases goods from an immediate buyer or other person in the normal chain of distribution. Alternative A to subsection 2. A seller's warranty to an immediate buyer, whether express or implied, a seller's remedial promise to an immediate buyer, or a seller's obligation to a remote purchaser under section 2-313A or 2-313B extends to an individual who is in the family or household of the immediate buyer or the remote purchaser who is a guest in the home of either, if it is reasonable to expect that the person may use, consume, or be affected by the goods, and who is injured in person by breach of the warranty, remedial promise, or obligation. A seller may not exclude or limit the operation of this section. Alternative B to subsection 2. A seller's warranty to an immediate buyer, whether express or implied, a seller's remedial promise to an immediate buyer, or a seller's obligation to a remote purchaser under section 2-313A or 2-313B extends to an individual who may reasonably be expected to use, consume, or be affected by the goods, and who is injured in person by breach of the warranty, remedial promise, or obligation. A seller may not exclude or limit the operation of this section. Alternative C to subsection 2. A seller's warranty to an immediate buyer, whether express or implied, a seller's remedial promise to an immediate buyer, or a seller's obligation to a remote purchaser under section 2-313A or 2-313B extends to any person that may reasonably be expected to use, consume, or be affected by the goods and that is injured by breach of the warranty, remedial promise, or obligation. A seller may not exclude or limit the operation of this section with respect to injury to the person of an individual to whom the warranty, remedial promise, or obligation extends. 2-319 and 2-320 and 2-321 and 2-322 and 2-323 and 2-324 are reserved.
We gotta find out why that is.
2-325, letter of credit, term, confirmed credit. If the parties...
Let me know whenever you want me to take back over.
If you want to, then go ahead.
No, I'm just saying whenever you...
Well, we're probably going to be at 9 o'clock in 15 minutes.
Oh, yeah. I didn't realize how close we were.
If the parties agree that the primary method of payment will be by letter of credit, the following rules apply. A. The buyer's obligation to pay is suspended by seasonable delivery to the seller of a letter of credit issued or confirmed by a financing agency of good repute in which the issuer and any confirmer undertake to pay against presentation of documents that evidence delivery of the goods. B. Failure of a party seasonably to furnish a letter of credit as agreed is a breach of the contract for sale. C. If the seller of credit is dishonored or repudiated, the seller or seasonable notification may require payment directly from the buyer. 2-326 Sale and approval and sale or return, consignment sales and rights of creditors. 1. Unless otherwise agreed, if delivered goods may be returned by the buyer even if they conform to the contract, the transaction is A. A sale on approval if the goods are delivered primarily for use, and B. A sale or return if the goods are delivered primarily for resale. 2. Goods held on approval are not subject to the claims of the buyer's creditors until acceptance. Goods held on sale or return are subject to such claims while in the buyer's possession. I'll reread it so you can understand it better. 2.
You know how I feel now.
Goods held on approval are not subject to the claims of the buyer's creditors until acceptance. Goods held on sale or return are subject to such claims while in the buyer's possession.
It's those different colored words that throw you off when you're reading. They just pop out at you and you just want to emphasize them.
Well, I went up when I should go down. 3. Any or return term of a contract for sale is to be treated as a separate contract for sale under Section 2-201 and as contradicting the sale aspect of the contract under Section 2-202. Section 2-327 Special incidents of sale on approval and sale or return. 1. Under a sale on approval, unless otherwise agreed. A. Although the goods are identified to the contract, the risk of loss and the title do not pass to the buyer until acceptance. And B. Use of the goods consistent with the purpose of trial is not acceptance, but failure seasonably to notify the seller of election to return the goods is acceptance. And if the goods conform to the contract, acceptance of any part is acceptance of the whole. And C. After due notification of election to return, the return is at the seller's risk and expense, but a merchant buyer must follow any reasonable instructions. 2. Under a sale or return, unless otherwise agreed. A. The option to return extends to the whole or any commercial unit of the goods, while in substantially their original condition, but must be exercised seasonably. And B. The return is at the buyer's risk and expense. Section 2-328 Sale by auction. 1. In a sale by auction, if goods are put up in lots, each lot is the subject of a separate sale. 2. A sale by auction is complete when the auctioneer so announces by the fall of the hammer or in other customary manner. If a bid is made during the process of completing the sale, but before a prior bid is accepted, the auctioneer has discretion to reopen the bidding or to declare the goods sold under the prior bid.
How are you getting all the easy paragraphs?
I want to interject. I want to interject something.
Go ahead.
So, think about that relating to a judge about to drop the gavel. That's all. Number
Wait,
okay.
Let's reread that.
Well, if a judge is an auctioneer and he's about to drop the gavel, maybe we want to think about these rules relating to that. I don't know.
Yeah, I like that. Sale by auction, because that's really what they are. They're selling off the securities.
Right.
Holy shit.
Okay. Number 3.
That explains the whole 3 times rule. They test you 3 times rule. Going once, going twice, sold.
So you have to slip your words in there before he slams the hammer. Like you I take exception.
You better not let the DA sell that bond, because I'll fucking sue, because I own it.
Like I take exception, or I just some other offer. You have to counter offer real quick. Yep. Number 3.
As he's swinging.
Yeah.
Or put in a bid.
Yep.
You'd have to put in a higher bid. How about 1 copper penny?
I would just say, how about 1 gram of silver bullion?
Or 1 real, what do they call it? 1 real dime that's silver. That's like,
Yep.
I forget the percentage of silver. Yeah, 1 silver dime.
Anything silver.
Right.
Anything silver. It's done.
Because anything, 1 silver dime
It's
would
worth all of the paper money in the world.
Right, would outbid all of their units of whatever, their fake money. Number 3. A sale by auction is subject to the seller's right to withdraw the goods unless at the time the goods are put up or during the course of the auction it is announced in express terms that the right to withdraw the goods is not reserved. In an auction in which the right to withdraw the goods is reserved, the auctioneer may withdraw the goods at any time until completion of the sale is announced by the auctioneer. In an auction which the right to withdraw the goods is not reserved, after the auctioneer calls for bids on an article or lot, the article or lot may not be withdrawn unless no bid is made within a reasonable time. In either case, a bidder may retract a bid until the auctioneer's announcement of completion of the sale, but the bidder's retraction does not revive any previous bid. 4. If the auctioneer knowingly receives a bid on the seller's behalf, or the seller makes or procures such a bid, and notice has not been given that liberty for such bidding is reserved, the buyer may, at the buyer's option, avoid the sale or take the goods at the price of the last good faith bid prior to the completion of the sale. This subsection shall not apply to any bid at an auction required by law. But we have public policy. We don't have law.
That's true. That's very true.
But
once we start bringing it into common, though.
But in Grant Gilmore's Admiralty law, they do call it law.
Do they?
Yeah.
Oh, yeah.
They changed the definition of law.
Oh, of course they did. Of course they changed it.
Title, creditors, and good faith purchasers. 2-401, passing of title, reservation for security, limited application of this section. Each provision of this article with regard to the rights, obligations, and remedies of the seller, the buyer, purchasers, or other third parties applies irrespective to title to the goods, except where the provision refers to such title. Insofar as situations are not covered by the other provisions of this article, and matters concerning title become material, the following rules apply. 1. Title to goods cannot pass under a contract for sale prior to their identification to the contract. Section 2-501, and unless otherwise explicitly agreed, the buyer acquires by their identification a special property as limited by this act. Any retention or reservation by the seller of the title property in goods shipped or delivered to the buyer is limited in effect to a reservation of a security interest. Subject to these provisions and to the provisions of Article 9, title to goods passes from the seller to the buyer in any manner and on any conditions explicitly agreed on by the parties. 2. Unless otherwise explicitly agreed, title passes to the buyer at the time and place at which the seller completes performance with reference to the physical delivery of the goods, despite any reservation of a security interest, and even though a document of title is to be delivered at a different time or place, and in particular and despite any reservation of a security interest by the bill of lading. A. If the contract requires or authorizes the seller to send the goods to the buyer, but does not require the seller to deliver them at destination, title passes to the buyer at the time and place of shipment. But B. If the contract requires delivery at destination, title passes on tender there. The property follows the title. So wherever you put your title may save your property. Like if your title is in England, I'll leave it there.
let's go ahead and talk about it.
Let's expand on that real quick.
Your property follows the title.
Right.
I think that's the saying. So if you put your title somewhere else, like in England, I'm wondering if it's in a trust or you, somehow record it there.
Holder in due course.
You have
Foreign
maybe
trust.
it's
Put it
registered
in a
as
foreign trust, and there you go.
an address there. Then the cop's not going to like that when if he pulls you over.
But on top of that, on the title, don't they have like the address with the zip code, making that like color of law, using their information?
I don't know. I don't want to act like some expert. I'm just passing on little things I've heard. Okay. Number 3. Unless otherwise explicitly agreed, where delivery is to be made without moving the goods. A. If the seller is to deliver a tangible document of title, title passes at the time, when, and the place where he delivers such documents, and if the seller is to deliver an electronic document of title, title passes when the seller delivers the document. Or B. If the goods are, at the time of contracting, already identified and no documents of title are to be delivered, title passes at the time and place of contracting. 4. A rejection or other refusal by the buyer to receive or retain the goods, whether or not justified, or a justified revocation of acceptance revests title to the goods in the seller. Such revesting occurs by operation of law and is not a sale.
Dun, dun, dun. And with that, we will call it good for the reading for tonight, because it's 9 o'clock. Unless you guys really want to go longer or something.
I'm fine.
I'm good.
Is that a yes? Is that a
I
no?
don't know. Whatever you want.
I don't have nothing to do.
Okay.
I'm getting kind of tired, so I think I'm good with the reading. I mean,
Okay.
if we want to continue and discuss, I'm okay with that.
Okay. Sounds good.
Because I've soaked up a lot of information today outside of this and inside of this. So discussing is good if we want to keep on with the discussion.
What other than a vehicle could we relocate the title for?
Property.
Mm-hmm.
Ourselves.
Maybe
Assets.
account. Could we do just plain bank accounts? I don't know.
I moved my bank account into trust.
Uh-huh.
Yeah.
Oh, could we talk about addresses? Non-domestic?
Oh, non-domestic addresses. I love non-domestic addresses. They're so simple. It's basically just write everything upper lowercase, put your care of in front of your address. Try to use a P.O. box if you can, or a suite. Get a P.O. box, call it a suite, same friggin' thing. Your town and state will be upper lowercase, not all uppercase like you always see it printed. Your zip code will be in brackets. That puts it in the four corners rule, so it's omitting it from being on the document, which forces it to be in the Republic realm. And then immediately under that, you write non-domestic, non-domestic / non-assumpsit. And
hey, have you? Sorry.
Go ahead.
I was gonna ask, have you seen some of the people that put -9998 with their zip code?
Yep, you can do that too.
I've actually went and looked up the post office that's near me. I looked up their address, and their address is -9998. So
Right.
I think if you use their address and then the PO box is a suite -9998, I think
Yeah. Yeah, because
works.
what that does is that delivers it directly to the post office, and then they put it from there.
Okay. How about what do they call it? Free mail or tax. What do they call it? Pretty much where they do their thumbprint and
Oh,
send
tax
mail
per
for
queue.
free.
Tax per queue.
Tax per queue. There you go.
I have yet to test it myself. I've seen plenty of examples of it working to know that it works. I've just been too nervous to use it on any of my documents. I'm probably, in all honesty, going to use it for my 15 to 18 packages that I have to send out here for my affidavit of life and my notice of cease and desist. So yeah, that'll probably be my first test, because otherwise it's going to be a ridiculous amount of money to ship out that many packages, dude. It's going to be insane.
Yeah. Yep.
And there's plenty of blue mailboxes around me, so I have no problem finding blue mailboxes to drop them in. And I'm in really, really good with my mail carrier that comes to my job. So if she sees my name on anything, chances are it's going to go through.
Cool.
So we'll see. But yeah, the mailing stuff, I love all of the information with the mailing. The $1 stamp, $5 stamp, 2-cent stamp, all of those are backed by precious metals.
The red box stamp 3036.
Yep.
Can you repeat that, John?
So the $1 stamp, the $5 stamp, you've got the red fox is the $1, and the $5 is what, the raccoon, or was it something else? Anybody know? Cal over there falling asleep.
Yeah, I noticed. I noticed those red box stamps. They have 2 lines through the S symbol.
Yes.
Instead of just 1 line.
Yes, that's how you know that it's backed by gold.
Now, is there any way to actually like get gold for it, like exchange it, or is it just more of
no
a contract?
It's
contract or consideration. For contract.
It's right. It's consideration for contract. So when you put a $1 stamp to an instrument, that instrument is now backed by gold. You put it on the back side of an instrument in the corner, red thumbprint over it. That's your final say. You can also convert it to a gold instrument at that point. I'm not sure of exactly how that process works, so let me put that out there. But
well, let me share a little story. I just recently got done sending some debt validation letters and going through that process. On a few of the validation letters, I went ahead and put a red thumbprint on all the stamps on those documents. And then on separate validation letters, I only did a stamp on the, my thumbprint, a red thumbprint on the back stamp. The stamp in the front, I didn't cancel that one out. And the collection company went ahead and sent everything back. They didn't even want the documents that had the stamps on it that weren't canceled out. But the other collection companies, I noticed that they kept the documents because all the stamps were canceled out on it. So I had actually put my thumbprint on all of the stamps on the documents.
yeah.
So if you,
Interesting.
so I'm thinking, well, from what I understand, like when you do a stamp, your thumbprint, your, you know what I'm saying, the social, and then I guess like the birth date next to it.
Yeah.
That's supposed to be like your seal.
Right.
And then the other stamp that you put on it, not canceled out, is the consideration. I'm thinking that's probably why they sent the whole thing back to me too. So.
Yep. Very well could be.
And I know that the box rule works. I had a situation where I went into court. It was for one of these. I ended up sending some letters or whatever, so they discharged it. But before I went into court, they wanted me to go ahead and pay for the court case. And I told them that I didn't have any money to pay. So they gave me some forms to go ahead and fill out. So I filled them out. But what I did is I put a box around my signature and
Yep.
submitted it. And then the day of court, they told me that it was denied because there was no signature on it. And I told the lady, I was like, I'm pretty sure I put a signature on it. So she pulled up the scan, and it shows my signature, but I have the box around it. So the judge said, yeah, but there was no signature on it. So I know the box rule works. And that's crazy because if you think about it, man, almost every single contract that you get from like these financial
has a
institutions,
box.
the interest rate's in a box. The names
Everything's
in a box.
the whole friggin' thing's in a box.
Yes.
That's why when you
even in like some of these the passports and stuff, you got boxes around like every single, like for the address and the digits and all that other stuff. It's like,
Yep.
man, everything's in a box.
dead because the entity is dead.
Exactly. See, this is why I got me a world passport. No boxes.
Nice. Do you know anyone that's gotten the 5-star passport or whatever that they say they get
No.
from that moonshine copper still or whatever?
Yeah, I keep hearing about it. My uncle and I are in the process of trying to get that done. I think for us it's not going to be that hard. I think it's going to be a lot easier for us because we've already corrected our status, and that legal note. You know what? I'm going to do y'all a favor. I'm going to kill y'all with kindness. I know I said I was done reading, but I'm finna read my legal notice of demand.
Nice.
Because this motherfucker is fire. So,
I like it.
legal notice and demand. Fiat jurisdicta ruat colium. Let right be done though the heavens should fall. To all state, federal, and international public officials, this is a contract in admiralty jurisdiction. This title is for your protection. Notice to agent is notice to principal. Notice to principal is notice to agent. Attention, any and all governments, municipalities, cities, townships, public officials, lending institutions, brokerage firms, credit unions, depository institutions, insurance agencies, credit bureaus, and aforementioned officers, agents, and employees therein. This is a notice of the law applicable to your corporate and personal financial liability in the event of any violations upon the rights, privileges, and immunities and or being of John Kennedy of the House of French or trust in representation thereof. This contract being of honor is represented under the good faith Oxford Doctrine. For a collateral list that is subject to this documentation, please see both security agreement under the item number, my security agreement number, and Schedule A. Definitions as they apply to this contract are enclosed in Attachment A and are included as a legal part of this contract. Any dispute of any definition will be decided by the undersigned. I, John Kennedy French, trustee, secured party, Bailey, hereinafter the undersigned, state in ensuing being of lawful majority, age, clear head, and sound mind, all responses, requests, and the like henceforth must be presented in writing, signed under penalty of perjury required by your law, as shown in this legal demand notice hereinafter contract. The law stated herein is for your clarification and not an agreement, omission, contract, covenant that the undersigned has entered or agreed to enter into any foreign jurisdiction. It has recently come to my attention that the IRS and the SSA and the federal courts have willfully been making injurious presumptions with prejudice to my constitutional rights by trying to associate me with the item sonus which is the all caps version of my Christian name, which is in fact a trust previously associated with the public office and the United States government by virtue of the Social Security number attached to it. Further information is to help clear up any presumptions to set the record straight. The undersigned tendering the document is a trustee, secured party bailee, and is in fact not 1, a straw man vessel in commerce, 2, a corporate fiction, 3, legal entity, 4, en legis, or 5, transmitting utility of, for, by, or to 1, the United States of America, 2, the government of the United States, 3, the state of Maine, 4, or the United States Corporation, also known as the United States Corp. USA, United States Inc., or by whatever name they may currently be known or be hereafter named, or any of its subdivisions, including but not limited to local, state, federal, international, or multinational governments, corporations, agencies, subcorporations, and any de facto compact corporate commercial states contracting therein, including the state of Maine, or by whatever name may currently be known or hereafter named, and the like. Further, the undersigned is not 1, a citizen within, 2, a surety for, 3, a subject of the United States Corporation, 28 USC subsection 3002-15A, also known as the Corporate United States Corp. USA, United States Inc., or by whatever name it may currently be known or hereafter named, excluding. Oh, sorry, I fucked that up. Hang on. Further, the undersigned is not 1, a citizen within, 2, a surety for, 3, a subject of, 4, an officer of, 5, and does not owe A, allegiance, B, fealty, bond, C, undertaking, D, obligation, E, duty, F, tax, G, impost, H, or tribute, 2, the United States Corporation, yada, 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 yada. This now being a matter of public record. This has been filed in my local county. This has been filed with the Secretary of State. This has been filed with Treasury. This went with my Form 56 too.
That's awesome. I like the part where you say you get to decide the definition of it.
Exactly.
Of words.
Exactly. And dude, and that's just the first page, bro. So, and there's still 8 pages to go. This gets juicy. The vessel in commerce, known as John Kennedy French, all caps, initially created as a trust, also known by identifying numbers, and that would be your birth certificate, by the government / parents for the benefit of the undersigned, John Kennedy French, as beneficiary on 3/10/81. On Friday, April 22nd, 2016, a waiver of beneficial position was declared to take up the abandoned post of trustee, secured party, bailee, to manage the affairs of John Kennedy French Trust for the benefit of the beneficiaries thereafter named in Registry of Trust for the following reasons. 1, matters are not being handled with efficiency. 2, in many respects, matters are not being taken care of at all. 3, usurpations of funds is occurring. 4, there is rampant fraud and deceit. 5, position of trustee has been left vacant or uncontested.
Hey, I had a question.
Yes.
Okay, so we're considered the authorized representative, the beneficiary, the equitable beneficiary, right? And are we considered the trustee too if you're setting up the trust that way?
Yes, you want to set up the trust as trustee. That's the whole point. Other people, like rookies, say, "Oh, you don't want to be trustee. You don't want to have all that responsibility." Well, that's the whole point, because it's not that much responsibility to begin with once you know how to do it. Like these processes, once you've figured out the process, you're talking what, 5, 10, 15 minutes a pop? You know? You're not doing anything it's paper pushing, man. It's fucking paper pushing.
Yeah.
But yeah, so the idea is because they haven't been handling the role of trustee properly, you need to take it over. Now, you're doing that until you get your death certificate, collapse of trust, and become executor. And then, at that point, you're, real big boy status. Doing securities, writing promissory notes, making checks out of the treasury. We'll get there. There's people that have gotten there in the last year or two, and they're out sharing, and a couple of them are connected with people that are coming into this group. So we'll get there. It's just a matter of time.
That's awesome.
Where was I? Oh yeah. Private offset account established at the United States Department of Treasury through the branch of the Federal Reserve Bank will remain in full effect from the initial date of creation, with current officer holder of Secretary of Treasury being provided appointment to trust to continue as fiduciary. Just below that, fraud gives the victim of the fraud the right to terminate his relationship to the government. Si qui custos fraudem pupillo faceret. I really cannot speak Latin. I have a Latin for Dummies book. I really need to start reading that one in the book club too.
Say that 3 times.
Huh?
Say
yeah,
that
no, I ain't even saying it one time. What the hell are you talking about? If a guardian behaves fraudulently to his ward, he shall be removed from the guardianship. Jenkins, Century 39, Bouvier's Maximum of Law, 1856. Boom. The similarity in the names of the undersigned and the vessel in commerce, two distinct and separate legal entities, is testament to the undeniable propriety. John Kennedy French Trust, originally an incorporeal creation of the government/parents, is dependent upon and only exists because John Kennedy French, a natural man, exists as a living, breathing, flesh and blood sentient being. So in the second page, in the first page, you've got your legal notice of demand that you are not the straw man, right? And what the straw man is and who the players are. In your second page, in the first paragraph of the next section, you've already got your affidavit of life in one sentence. Because it tells you flat out it's dependent upon and only exists because John Kennedy French, a living man, exists as a living, breathing, flesh and blood sentient being. The government, being an incorporeal entity, can only engage other incorporeal entities and not real flesh and blood humans. Therefore, the creation of a vessel in commerce, known commonly as John Kennedy French Trust, was highly advantageous to the government to interface with. Since the birth of the undersigned, the government has utilized the credit and future earning potential of the undersigned, establishing and operating a private offset account through the use of the vessel in commerce, John Kennedy French Trust, without the knowledge, consent, or permission of the undersigned, acting to the detriment of the beneficiary, John Kennedy French Trust, or John Kennedy French, against the basic precepts of a trust. Sorry, I fucked that up. Let's start that over. Too many commas. Since the birth of the undersigned, the government has utilized the credit and future earnings potential of the undersigned, establishing and operating a private offset account through the use of the vessel in commerce, John Kennedy French Trust, without the knowledge, consent, or permission of the undersigned, acting to the detriment of the beneficiary, John Kennedy French, against the basic precepts of a trust. During this time, the undersigned has unknowingly been functioning as a manager of the trust and signing as an authorized representative for the vessel in commerce by signing bank checks, applications for credit, and notes on behalf of the vessel in commerce. Now, the undersigned acts knowingly not in a beneficial position, but as manager trustee of the trust. The undersigned has valid documentation waiving beneficial position for the position of trustee secured. That has valid documentation waiving beneficial position for the position of trustee secured party bailee, submitted as a matter of public record, by which the undersigned became trustee secured party bailee to the John Kennedy French Trust and has full operating authority. The undersigned, having full control of the trust, revokes all permissions to the government and or any political subdivisions, organizations to use copyrighted trust name John Kennedy French Trust or trust in any fashion by explicit written request, order, or in direction otherwise. Said name belongs to trust in operation by trustees wherein the government agencies thereof have no control as trustee secured party bailee, having full mental capacity and to contract, as well as natural right to trust, holds a common law trade name trademark, John Kennedy French, as authorized representative, attorney in fact, as well as established validity of power of attorney by continual non-contested use. The private offset account established in the name of trust is the property of trust, as well as any value that has been deposited in private offset account is the property of trust, as any such value was created from the credit thereof. Account will remain in effect with appointment of a fiduciary by Form 56. The undersigned now tendering this binding legal notice of demand, having herein above declared trustee secured parties trust proper legal status and relation to the Republic of Maine and to the said de facto compact corporate commercial states. Oh, what the fuck did I get myself into on this one? Including the state of Maine, or by whatever name it may currently be known or hereafter named, does hereby state the declarations and statements made herein are truth, the whole truth, and nothing but the truth to the best of the trustee secured parties' knowledge. Acknowledged by silence and acquiescence of the Maine Secretary of State, also but not limited to any public offices, agents, contractors, assigns, employees, and subsidiaries of said office regarding the trustee secured parties' notice and demand, is therefore accepted and agreed to be truth. With silence of corporate office, Secretary of State ratifies severance of any nexus or relationship between trustee secured party trust and the said de facto corporate commercial state offices, being fraudulently conveyance operating under color of authority. Let this be known by the good faith Oxford doctrine to all men and women. The undersigned nor trust consent to any warrantless searches or seizures that are not complaint with the Constitution for the United States of America. All of the amendments of the Honorable Bill of Rights and or the Constitution of the State of Maine, whether the undersigned or trust dwellings, cars, lands, crafts, watercrafts, aircrafts, the undersigned himself and current location, property, hotel rooms, apartments, business records, business or machinery, vehicles, equipment, supplies, buildings, grounds, land, in private possession or control of the undersigned trust, past, present, and future, now and forevermore, so help me God. This notice is in the nature of a Miranda warning, where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. Take due heed of its contents. If for any reason you do not understand any of these statements or warnings, it is incumbent upon you to summon a superior officer, special prosecutor, federal judge, or other competent legal counsel to immediately explain to you the significance of this presentment as per your duties and obligations in respect to this private, formal, notarized, registered statute staple securities instrument as per Title 11, USC 501A and 502A, and Federal Rules of Civil Procedure Section 8A and 13A. The claim or presumption that I, John Kennedy French, or John Kennedy French Trust, simply known herein as trust, as aforestated, am not a citizen within, surety for, subject of, and do not owe allegiance or fealty as aforestated to any of the aforementioned or the like, and herein is forever rebutted by this counterclaim in admiralty. By this record, let it be known that the undersigned and trust do not at any time waive any rights, capacities, privileges, immunities, defenses, or protections as acknowledged by the Constitution for the United States of America, the Honorable Bill of Rights, and or the Constitution of the State of Maine. Nonetheless, demanding that you protect these as you swore an oath or oaths to do so. The undersigned accepts your lawfully required oaths of office, bonds you of any type, insurance policies, CAFR funds, and property of any type for protection and making whole. Furthermore, should you witness any public officers at this time or at any time past, present, or future violate any of the rights, privileges, immunities, defenses, or protections of the undersigned or the trust that he represents, it is your sworn duty of oath to immediately arrest or have them arrested. You are legally required to charge them as you should any lawbreaker, regardless of an officer's title, rank, uniform, cloak, badge, position, stature, or office. Or you shall henceforth be accountable for monetary damages from, but not limited to, your monetary liability, your corporate bond, compensatory costs, punitive procurements, and sanctioned by attorney attributions. Note: a true and corrected notarized copy of this statute staple securities instrument is on file not only with the Secretary of State's office, but also been delivered to several trusted parties, apprising them of the undersigned's policy, presenting the security instrument to each and every public officer who approaches the undersigned or the trust violating the undersigned and or trust unalienable rights, including but not limited to right of liberty and free movement upon any common pathway of travel. The undersigned has a lawful right to travel by whatever means via land, sea, air, without any officer, agent, employee, attorney, or judge in any manner willfully causing adverse effects or damages upon the undersigned by an arrest, detainment, restraint, or deprivation with regard to any encounter or communication with the de facto compact commercial states, including the state of Maine, by whatever name it may currently be known or hereafter named. The undersigned will be granted the status and treatment of a foreign sovereign, a foreign diplomat, by all custom officials. This document or the deposited copy thereof becomes an evidentiary document certified herein as if now fully reproduced. Should any court action be taken upon the undersigned as caused by your acts under the color of law with you, your officers, or employees, take note, you are now monetarily liable in your personal and corporate capacity. The undersigned, notwithstanding anything to the contrary, abides by all laws in accordance with the Constitution of the United States, the Honorable Bill of Rights, and or the Constitution of the State of Maine, which are applicable to non-domestic, non-assumpsit, non-residents on sojourn. The undersigned wishes no harm to any man or woman. You agree to hold up my right of travel. Be warned, noticed, and advised that in addition to the constitutional limits of governmental authority included in the Constitution for the United States and Honorable Bill of Rights and or the Constitution of the State of Maine, the undersigned relies upon the rights and defenses guaranteed under the Uniform Commercial Code, Common Equity Law, Laws of Admiralty, and commercial liens and levies pursuant to, but not limited to, Title 42 USCA Civil Rights, Title 18 USCA Criminal Codes, Title 28 USCA Civil Codes, to which you are bound by the office and oath, and the Constitution of the State of Maine and Maine Penal Codes, in as much as they are in compliance with the Constitution for the United States of America, Bill of Rights, and or the Constitution for the State of Maine as applicable. There can be no violation of any of these laws unless there is a victim consisting of a natural flesh and blood man or woman who has been injured. There is no victim, when there is no victim, there is no crime. Remember, in taking a solemn binding oath to protect and defend the original Constitution of the United States of America, circa 1787, and or the Constitution for the State of Maine, against all enemies, foreign and domestic, violations of said oath is perjury, being bad faith doctrine by constructive treason and immoral dishonor. The undersigned accepts said oath of office that you have sworn to uphold. This legal and timely notice, declaration, and demand is prima facie evidence of sufficient notice of grace. The terms and conditions of this presentment agreement are quasi-contract under the Uniform Commercial Code and Fair Debt Collections Act. These terms and conditions are not subject to any or all immunities that you may claim should you in any way violate the undersigned's rights or allow violations by others. Your corporate commercial acts against the undersigned or the undersigned's own, and your failures to act on behalf of the same, where an obligation to act or not act exists, are ultra vires and injurious by willful and gross negligence. The liability is upon you and or your superior and upon including any and all local, state, regional, federal, multi-jurisdictional, international, and or corporate agencies, and the persons representing or attached to the foregoing involved directly or indirectly with you via any nexus acting with you. That's an important. Indirectly with you via any nexus acting with you. And said liability shall be satisfied jointly and or severally at the undersigned's discretion. You are sworn to your oaths of office, and I accept your oaths of office and your responsibility to uphold the rights of the undersigned or the undersigned's own at all times. Billing a cost assessed with levies, liens, and or tort upon violations shall be unlawful arrest, illegal arrest, restraint, distraint, or trespassing or trespass, $2 million per occurrence per officer. Holy shit. I just fucking realized. They pulled his ass. He could get $2 million off that shit. I got to figure out how to file a fucking indictment. That's a $2 million lawsuit right there because he already had this in the fucking record.
Now, did you file it in the county record?
I filed mine. He filed his in his court case. I filed mine as a miscellaneous a few weeks ago.
Okay, so that's what you have to do is open up a miscellaneous file.
Yep.
With the county recorder.
Yep.
Awesome.
Yeah, everything's pretty much 2 million, 5 million, a few of them, 3 millions. 200,000 if they deface your property.
So what would you do then? Would you just do like an administrative process saying, "Hey,
yeah, well, you would do it.
For...
You would do a billing because you put the fee schedule in. So you would do a billing, which would be an administrative process. You would want to take note of everybody that was involved. You want everybody's name in that building on that document because you get $2 million for each person, and we know how RICO works. And that's exactly why RICO's there, right?
How
there.
does
if you can prove one person,
what do you mean? We know how
so RICO is the conspiracy statute, right? So if you could prove that, if you could charge one person in a conspiracy with a crime, you could charge everybody with the same crime. So if you're able to charge one person in a courtroom with a crime, everybody that had hands on that paper trail is chargeable. From the officer from the get to the people that took the call and helped him to call it in, right on down. You can charge everybody. Did I lose you guys?
Nope.
No, I'm still here.
Okay, all right.
I'm just. So then you just send them a bill, and then turn around and give them so many days. Say that they hadn't paid, give them another so many days,
right?
And then default them, get it recorded. Oh, I see.
Unless there's another way to go around it that I haven't come across yet. But again,
and is that the same way
you student? You know, if it's all banking, you know what I mean. It's all you would think it's all going to be basically handled the same way, except maybe for the fact that you might have 1099s involved when you're dealing with the courts.
I see.
But I mean, essentially, it's all.
Hey, have you?
Go ahead.
Sorry, there's like a little delay or something on here. But I was gonna say, have you ever heard of or gotten into that David Wynn Miller guy?
No, I haven't heard anything about that guy. No clue who he is.
Oh, okay.
Yes, sir.
He gets into like he calls it parse syntax, but really I think what it is it's understanding that I mean, like you know how like all capitals represents the fiction, and well he goes further and shows that some words are a mixture of English and Latin.
Yes.
And if it's two different languages for one word, it's pretty much like I mean, they call it Babel.
Right.
But the other thing he was that he had mentioned was well, it was something that I learned from that Mark Keyshawn Christopher guy, but that all capital letters, like if you're going to use it in a sentence, you should have some kind of like period or dash in between each word, because I guess based on like the Chicago Manual of Styles, if a word is in all capital letters and it's not connected with like a dot or a dash in between words, then it represents like a sentence and in a period, meaning like each word is a sentence and a period. And something that I noticed was that on my the Morgan silver dollars, if you look at the e pluribus omnium on the top, all the words are in all capital letters, and there is like a little period or a dot in between each word. So what I've been doing is on my documents, if I have like words that are in all capital letters or sentences, I'll connect everything, and then I'll bracket in statutes and codes. That way it's like it's not there on the paper, so they can't say that you're using copyrighted material. If it is copyrighted, I really don't know. But
yeah, that's one of those
it
things.
shows that you
because it's copyrighted,
it just
but
shows
it's there
that
to be
you
used, so you know what the fuck.
Yeah. But so yeah, that's some stuff that I've been doing with some of my paperwork, and but yeah, I found it pretty interesting that when I looked at older coins, and actually let me see, I'll see if I think I have one right here. When you look at older coins, they do have like a period in between each of the capitals.
Yeah, my uncle came over today and he showed me some of his silver coins. Yeah, fucking coins, fucking 1884, 1887. What do you got there?
Yeah, so the E period pluribus period omnium. Omnium.
What year is that?
And then 1898.
Nice. So right around when the mud flood happened.
Is that when the mud flood happened?
Well, the Civil War never happened. The Civil War is bullshit. Most of our history that we're going by for this is actually bullshit. The Act of 1666 is actually the Act of 666. That's why they call 666 the mark of the beast, because that's when the trust was actually created. Because you have Tartarian maps that were purposefully mistranslated. They had an I in front of the number, not a 1, and that stood for the age, because the previous age had like a A or a B or something. There was a different letter in front of it, but they were going by letters, and what they did was they changed it to a number, and that didn't happen until the 1800s. And all of this was done in order to take all of the land from the Moors.
It's interesting you say that, because I think it was last week I watched a video where they were talking about mud floods, and it was showing buildings where like, they had like tons of layers underneath them.
Yo,
It was a
I
whole
could
building
throw
underneath
rocks.
It was just covered up.
I could throw a rock across the street from my house right now. I could turn my camera if it was daylight out right now. I could turn my camera to an old high school that's an old Tartarian building, part of the mud flood. I could show you two churches, a church on this side of town, a church on that side of town, and then an old post office, all part of a fucking mud flood. The post office, fucking mud flood comes down. You've got a fucking staircase built into the side of the fucking mud that goes along the side of the building, and yet 4 stories of the building is in the front of it is encased in mud, and you've got the back of it's wide open.
Wow.
It's like, how the fuck did a whole pile of fucking earth, who would fucking build a straight stone building into a pile of earth? Nobody does that.
Yeah.
And you've got all this earth,
true.
you've got all this earth coming up in front of it, and yet the building is perfectly straight. Dude, this whole fucking town that I live in is a fucking mud flood town. I shit you not.
Is it shaped in one of those like star forts?
You know what? There probably is a star fort around here. I'll have to look that up. I will have to definitely look that up. I wouldn't be fucking surprised at all. I really wouldn't.
Yeah,
because I walk by Tartarian buildings all day, every day. The state capitol here is a Tartarian building.
You look at archaeology, and they're always having to dig.
Yeah.
Underneath whatever ground is there. So I mean, everywhere you go.
So like everything that we've been told about our time, like it. And the other thing that made me grasp onto this so easily, this particular conspiracy, is the physical evidence can be found right around me. Like the fact that this is supposed to be a worldwide thing. I'm like, all right, then I should be able to find some fucking evidence, right? No problem. Walked outside my fucking door the very next day, and I'm like, ugh. But then you have The Matrix. One of the lines that Morpheus said was, we don't really know what year it is. You know, I'd like to tell you what year it is, but we don't really know. And that's because they fucked with the timeline so much. We know for a fact that they added 1,000 years. And that was just at this last reset. But there's evidence of previous resets. So how many times have they done this to us? Because they've used the same technology over and over again to make this happen. And just wipe us and then start over. And they just farm us.
I think that I mean, it had to have happened a few times, because I think the Hebrew calendar says that it's like the year 5005 something.
Yeah.
And I mean, they say we're only in 2000, so.
Right. But if we go by what the Tartarian maps were saying at the time, which have all been considered authentic and genuine by people that study maps, and these maps also prove flat Earth. So that's got to be like, okay, so what the fuck? But these maps are all dated 400, 500. Like one of them was 555, another one was 834. But there was an I in front of them all. And it's very clearly an I. It would either be an uppercase or it would be with a dot. But it was very clearly an I. The only way that you could know that it was an I and not... The other way that you could know that it was an I and not a 1 is because why would you have a Roman numeral next to regular numbers? What would be the point?
So it was the letter I in front of 3 numbers?
Yep.
I see.
At Tartaria, was what the Moors built. And see, they purposefully skewed the timeline to make everything seem like it was so much farther away, and then they filled it with repeating stories by changing the names. And then the reason they did that, so you don't know, obviously, if you don't know the history, you don't know what the fuck's going on. But if they can make it seem like all this stuff was so much further away, so far out of reach that it'll never be reduplicated and we don't know anything about it, that's bullshit. That's bullshit. It's fucking programming. But it's all
Hey,
right.
I just saw something. I don't know. It's all good. I just saw something the other day that I forgot what channel it was on YouTube, but they were saying that I guess they found the tomb of Alexander and Cleopatra, and that supposedly they were buried together, and that there's like tons of gold or something in there, somewhere in the Middle East, I think. The video was. I have to look back on my playlist here.
I'll have to research that one. I'll definitely have to research that one.
Let me see here. I'm trying to see if I can find it.
Cal, what's going on? What's going on in your head, brother?
It's pounding, my guy. That's why I'm quiet. I got tension in the back of my neck.
Well, why
headache.
the hell don't you go to bed, bro?
Hey, man, I can't pass up the knowledge, my guy. I'm trying to get out of this public sector like fast as hell.
Hey, I'm feeling you. Have you checked out that site yet? MakeFreedom.com.
MakeFreedom.com?
Yep.
No, I did not.
Check them out, man. That's the cats that did my trust for me. I'm gonna go to them right now.
Hold on. The man said, "Let there be light."
Yeah, see, it's still $150 for you to file it yourself.
What?
For you to get your initial process of getting your trust started and becoming a secured party creditor, it's $150 to file it yourself. They give you all the documents. You get exactly what I just read off. You get a copy of that.
My trust and all of my UCCs are already filed.
Oh, that's right. You got that shit already. All right. You got your W-8 Ben and your bond for investment, and
I have my indemnity bond done. I do not have the eight bin. That's why I wanted to discuss the death certificate. I seen that post the other day, and I downloaded that document.
Yeah, I haven't gone over that. You know what we might do?
I think I sent it to you too, Tim.
If everybody's down, or if anybody's down, I should say, we can meet tomorrow afternoon specifically to just go over that document. Just to read it and discuss and see if we can't come up with. So what I will do is, shit, how am I going to do this? I'm going to try and upload the John Does of my trust. And it'll be everything. How to fill out the W-8 Ben, the Declaration of Trust, the chargeback, the Schedule A, the whole harmless indemnity bond, the Form 56s, the common law copyright, the security agreement, the bond for investment.
I don't think I'm too far off.
It'll have all of that. And I also have instructions on where to send everything out. And you should be doing everything through New York.
When you say through New York,
all of your UCC filings.
My UCC is done.
Right. Well, you're gonna have more.
Why?
You're gonna have amendments. You're gonna have additions. This is just the beginning. The reason why you want to go through New York is because New York is Mecca.
Okay.
Everything gets accepted in New York. You can go to your regionals and you'll have a higher luck, but 9 times out of 10, if you go to your state, and unless your state is a regional, it's going to get denied more often than not.
Okay.
New York is the financial capital of the world and the Vatican. So everything operates out of there. They know what's coming. They know that the United States is about to go into another bankruptcy, and the old United States is about to come out of bankruptcy. And in that, we're going to get left with the bill. And they know that people have figured it out, and they know that people are coming to claim their titles. So that's why I say just go ahead and go through New York. It'll save you a lot of headache.
Yeah, I really want to hurry up and get this process done because I want to invest, purchase some property and assets for the corporation so that the executor have access to that stuff. Like
one of the key
property out here.
One of the things that we need to do is find out what they've done, what assets they've acquired in the name, and how to liquidate those assets.
Okay.
And I'm not sure if that's what liquidating the trust would actually be in the short term, or if that's like just the shorthand version of how to do that or what. But I know that's something.
It's already been approved by the corporation. I have to write up the acceptance form. When I moved out here to Arizona, I left a lot of stuff back in Washington because of my truck blowing up on me.
Yeah.
And I have to go back and get that stuff. A lot of my forms are already there. I have like 4 or 5 trust and estate books back there with all of that information in it.
Yeah.
So I just got to get back there and get my stuff.
Yep. All right, guys. It's just about 10 o'clock. I got to work in the morning.
For sure.
Actually, you know what, Marie, hang on. You ain't said nothing all night.
I have the page turning software ready. I have a conflict on Fridays because my group wants to start having Zooms on Fridays. So I'll have to skip that one, which is the secured transactions book.
All right. How about we move?
I don't want to make you move anything.
Well, no, because I had something on Fridays that I was looking to get into too. Cal, you know what I'm talking about. Brian Parker. That's Fridays at 7, right?
No, Sunday.
Oh, that's Sundays at 7. Sunday? Wednesday. I wouldn't mind. I wouldn't mind doing the other one on Saturday if anybody would be up for that. Just because trying to fit this in during the week with work is a little harder. Would anybody have objections to doing the UCC workbook on Saturdays?
Wait, we're talking about
I'm sorry,
Friday.
the secure transactions on Saturdays.
Okay.
Nope.
So what time? 7 p.m. Wait. What time zone are you in?
I'm in Eastern. It's 9:50. It's 10 o'clock here.
So you want Saturday evening? What time? Your time?
What would work for you guys?
I'm probably fine. Whatever.
I'm open to.
All right, 7 o'clock it is then.
So that's Eastern.
Yep.
Okay. Saturday.
That'll be a good way to top off the night. So, all right then, we got a plan.
I don't have the documents though for the estate and trust administration. So should I just get? I should just get that from your.
Yeah, they're in the ones that I can, because I can't find a PDF. I tried to find a PDF.
Okay.
For a trust?
For the trust and administration for dummies. So I just took pictures and posted them up in the group.
Okay. All set.
So, alrighty. Well, thank you again, guys. I appreciate all your time. And Marie, a special thanks to you for reading.
You're welcome.
You're awesome.
So, yeah, that's my other, my AKA Awesome Lawsome.
All right, everybody have a good night.
You
Bye.
too, man. Appreciate your time
Blessed.
also. Just have a good evening.
Thank you very much.
Namaste.
Have a good night. Namaste.